Hello, Vince Rubino here. Today I would like to discuss the effect a bankruptcy filing has on someone's credit. Most people like you and I who find themselves with no choice but to file for bankruptcy file under Chapter 7. So for the purpose of this video we will focus on the effect that Chapter 7 bankruptcy has on credit. First of all, let me start by saying that what we will discuss presumes that an experienced attorney is of the belief that a bankruptcy filing is appropriate under the circumstances. There are potentially preferable options for resolving debt and maintaining or improving credit. The initial impression you might have regarding the effect a bankruptcy filing would have on someone's credit is the same one I first had taking a bankruptcy course in law school. If you file for bankruptcy, your credit will drop like a stone. And yes, if you have good credit score and file for bankruptcy, you could expect that score to suffer. But in reality, almost anyone filing for bankruptcy has already had enough late payments, defaults, and collection letters that has already taken a toll on his or her credit report. Yes, a bankruptcy filing could make it even a bit worse, but if someone already can't get a car loan, they have nothing to lose credit-wise by filing for bankruptcy. After all, the primary purpose of having what we commonly refer to as good credit is to get more credit. A mortgage, a car loan, or a credit card. But if you cannot get credit, then at that point there's really nowhere to go but up. If all goes well, a Chapter 7 case lasts about 4 to 5 months start to finish, at the end of which the debtor, who is the person filing for bankruptcy, receives a discharge order from the court. The discharge order is the court's determination that a person's dischargeable debts, those which can be erased in bankruptcy, have indeed been eliminated. Most people I meet are of the opinion that a bankruptcy discharge may remain on a person's credit report for up to 7 years. Actually, it's 10 years, which isn't nearly as bad as it sounds, as I'll explain in a little while. But first I would like to discuss the 7-year rule, which does indeed exist, but just not with respect to bankruptcy discharges. Under federal law, defaulted debt may remain as a negative item on a credit report for up to 7 years. That means that if I'm late on my car loan payments this month, it can appear on my credit report 7 years from now. Will that in and of itself ruin my credit? No, particularly if I don't have a history of late payments on that loan or others. But if a debt falls in such default that it goes to collection, that will of course be worse for my credit and my ability to secure future credit. Worse yet, let's say I have a debt that is in default month after month, and after 2 years the creditor sues me and obtains a judgment. The initial default is going to appear on my credit report for 7 years, then the entry of the judgment will be treated as a new event which can also appear on my credit report for 7 years. And every time I apply for credit, that judgment will show up, making it more difficult for me to obtain a mortgage for the house I was hoping to buy, or obtain a loan to secure a more reliable car to get back and forth to work. When we apply for a loan, what is the lender's primary concern? It's whether or not we'll be able to repay them, of course. If defaults appear on our credit report, or worse yet, lawsuits or judgment, then there's a concern that in the future our wages could be garnished or bank accounts levied by those creditors, rendering us unable to repay the loan for which we're now applying. The bank isn't making any personal judgments about us when looking at the credit report, but it is making a practical and mathematical prediction about our ability to repay. Defaults on our credit reports indicate a reduced likelihood of repayment. This is where a bankruptcy filing could help. I said that a bankruptcy discharge could remain on a credit report for up to 10 years, but that it isn't nearly as bad as it sounds. Yes, perhaps the debtor did fall so far behind with debts and had such significant defaults, and maybe even lawsuits, that he or she felt the need to file for bankruptcy. However, the discharge issued by the bankruptcy court has eliminated those debts. The result of that is that the credit cards or medical bills or personal loans or car possessions which before the bankruptcy could have tried to garnish my paycheck or freeze my bank accounts can no longer do so. The discharge makes it more likely that I will be able to repay the loan, making me a better credit risk. Does that mean that the day after my discharge I'll be able to get a loan for a new car? No, but presuming that, number one, I haven't gotten into financial trouble again, number two, I have the requisite down money, and number three, I have the income and work history to support repayment of the loan, I can very well look forward to obtaining an auto loan at ordinary rates after only 2 years since the bankruptcy filing. Let's map that out. Let's say the bankruptcy case lasts 5 months from filing to discharge. 2 years after that, which is 2 years and 5 months after the bankruptcy case was filed, it's ordinarily possible to get a car loan like anybody else. A mortgage at ordinary bank rates isn't possible until 4 years after the discharge. Although what I like to refer to as half-decent mortgage rates, often called A- paper, could be possible only 2 years after discharge. Like I said, the bankruptcy discharge remaining on the credit report for 10 years may sound like a lifetime, but decent credit can be secured long before that time. Please note that I am not recommending that a bankruptcy filing is the best way to clean up poor credit. Chapter 7 cases are ordinarily used to protect debtors from active collection activity or lawsuits. If negative items on a credit report are the sole problem, I like to look at the report to see how old the debts are. The debts may be so old that they will soon fall off the credit report, or the statute of limitations may have passed, giving my client a defense if the creditor attempts to sue. In addition, there are mechanisms to correct inaccurate information on credit reports. An experienced attorney can explain these options to you, and in addition, there is ample information regarding credit reporting from credible sources on the internet. I hope this information was useful. Thank you.